Privacy seems like an increasingly elusive goal as our society becomes ever more digitalised, and it seems like our every move could be tracked by our interactions with websites and social media. In the health sector, as health records become digital, information is stored in clouds, cyber attacks hit hospitals and practices, and AI is used in everyday consultations, our patients are becoming increasingly aware of privacy issues, and they're often concerned about what has been written in their notes and who we share that information with. At MPS, a significant proportion of the calls we get to our advice line involve questions about privacy. And although the number of cases that actually end up being investigated by the Privacy Commissioner is small, compared to the HDC, those cases can be significant, and I think we can all agree that if we can, it would be better to avoid the Privacy Commissioner's gaze. So welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Today we're looking at privacy pitfalls, and we're very lucky to have as our guest Stephanie Gregor, who's the Manager for the Capability and Guidance area of the Privacy Commission. And we feel very privileged to have her expertise to help us work through some curly privacy issues that our members so often bring to us. So welcome, Stephanie.
Thanks, Lucy.
I also have with me my colleague from MPS, Dr. Sam King. Hi, Sam.
Hey, Lucy.
And also Mr. Adam Holloway, who's a partner at MPS's panel law firm, Wood & Kearney. Hi, Adam.
Hello, Lucy.
Okay, so we're talking privacy today, and I thought we'd just start with some basics. So, Sam, it's up to you. You're going to give us a brief overview of the privacy framework we work within as healthcare practitioners.
I thought I'd start by reading the entire Act. Would that be suitable?
Yeah, maybe.
So the Privacy Act 2020 forms the basis of the Health Information Privacy Code. And usually for clinicians, that's what we follow, what we call the HIPC. And generally, the code goes through what can be collected, what you can use it for, who gets to see it, how to store it, how to get rid of it, and all those kinds of things. So it's a very useful code, and if any of you haven't had the opportunity to look through it, I think it's definitely worth a view. And on the Privacy Commissioner's website, there's a whole lot of training courses that you can do that are free. And if you need to train your staff or get upskilled, I would head to those pages. Not only that, but we do have quite a number of podcasts on privacy, and you'll find some fact sheets on various privacy questions that we get asked all the time. So feel free to avail yourself of that.
Okay, so just to be clear, for the rest of the podcast, we're going to refer to the Health Information Privacy Code as the HIPC, because it's just a bit less of a mouthful. So look, we're not going to go through all the rules in detail now, but I'm sure we'll be talking about some of them as we go through our scenarios. But I am going to ask Adam the question that our members commonly ask us when something's gone wrong. What is the worst that can happen to me if the Privacy Commissioner finds me at fault?
The Privacy Commissioner will generally make efforts early in the process to try and get the two parties to reach a settlement or to resolve the matter between themselves. If that's not, and that could involve potentially being encouraged to make an apology or even pay some money to the person whose rights, who's claiming that their rights have been breached. If it can't be sorted out early, then the Commission will take a look at it, and their team will ultimately, after a bit of back and forth and sort of written conversation where each side puts their case, express a view about whether or not the complainant's right about their rights being infringed. And at the end of that, there might be another effort to try and achieve settlement. Ultimately, if a complaint can't be settled, and really whether or not the Privacy Commissioner thinks that there has been a breach, a complainant is entitled to take a case against you to the Human Rights Review Tribunal. In rare cases, the Commissioner's team themselves, through someone called the Director of Proceedings, can do that, but typically it would be the aggrieved person takes a claim to this special court called the Human Rights Review Tribunal, one of that tribunal's jobs is to determine privacy issues, and they have the ability to ultimately award damages against you if you have infringed someone's rights.
Can I just ask, going back a bit, you said that the Commissioner tries to get the parties to come to an agreement and a settlement themselves.
Yeah, well, I suppose that so I've got a dispute resolution team at the Office of the Privacy Commissioner, and a lot of them are sort of trained conciliators and mediators, and the way that they run these conciliation conferences where they're facilitating these is trying to help the different parties actually just come to an agreement and about what the right thing is. So, there might be some pushing, but it can never be that the Office of the Privacy Commissioner will say, you have to take this, you should definitely do it this way, those kind of things. The point is to help those two parties actually be able to work out what is sort of acceptable for both of them.
Mm. And who pays? Does the doctor pay, or the practice pay, or the hospital, or is there a system?
Don't the complaints come against, you always take the practice or the agency, the complaint comes against them. I mean, we've got a case at the moment, haven't we, where it's not the individual who is at the centre of the complaint, it becomes the practice.
Yeah, it's the agency that's responsible. Yeah.
So even if the person where a breach happened was an employee who was doing something that was clearly against what was common practice or the protocols, actually the Privacy Commissioner won't be dealing with that individual. They'll be dealing with the agency who employed them and who was holding the information.
Yes, that's right. But which is not to say that if there is sort of an arrangement reached, that there isn't something that the clinic itself can actually have with the individual in question. It might become a human resources thing or a code of conduct issue and those kind of things. But as far as the Privacy Act goes, it's about the action of the agency, and the action of an employee is deemed to be an action of an agency.
Is there a reason for that? It does seem a little unfair at times. It's just the way it is.
It's just that the thing is, if the employee was doing something that they'd specifically been told not to do, and that the practice had processes in place and education in place and everything else in place to say don't do it, and then the employee does it, that it does seem a little bit unfair on the clinic who've actually tried very hard to have a good privacy process to be held responsible for the actions of somebody who did exactly what you told them not to.
I think my perspective on that is, in essence, what the Act is saying is that an agency that employs people was going to be vicariously liable for the actions of its staff in most circumstances, and I'll come back to that. And that can feel unfair, particularly for a small business, where this is a huge imposition on, a two-partner GP practice. This can really feel like it takes over your life, and you've been let down by a staff member who's accessed clinical records they shouldn't have, for example. But if you take a big step back, there's a lot of areas in the law where the solution is to impose vicarious liability like that. The reason being that from a policy perspective, you're incentivizing the right organisation to take care, and you're also putting liability at a level where you can expect that risk to be insured and managed. Whereas if it only sat at the individual level, what you might see much more commonly is people who are genuinely aggrieved, but they don't get a remedy because the person's disappeared or they've got no money. So there are good policy reasons for putting the liability at that. The Act does include a narrow defence that you can raise if you are truly blameless. I'm not an expert in that area. I'm going to go out on a limb and say I don't think that that's particularly well tested at the tribunal level. How far that defence runs, it might be something that we often mention, but it's hard to be really clear when we're giving advice about whether that defence is going to be able to be relied on in particular cases. It does often feel, though, quite raw, I think, where you've got someone who really has done something that they were told not to, and they're not the one who's having to come to these meetings and pay the money.
I agree. Okay, so with that in mind and thinking about those consequences and the process that we might be involved in, let's have a look at some of the scenarios that we've taken from calls on our advice line. So look, I want to start with a brief disclaimer because privacy cases often turn on the specifics of an individual scenario. So while we're talking about generalities in these cases, look, if you do have a specific issue and you're a member of MPS, you can call our advice line, which is 0800 2255 677. Or you can call the Privacy Commission and talk to one of Stephanie's colleagues for advice, and their phone number is 0800 803 909. So if you've got questions, I think, and it's always, particularly for privacy cases, it's better to ask before you do anything rather than do something and then ask later whether that was a good idea. So, yes, as I say, this is general advice, but if you've got any questions, just call and ask. So, starting off, Stephanie, we're going to talk about patients asking for a copy of their notes from the practice. And we've been asked if the patient has access to all their notes through a patient portal, is it still reasonable for the practices to pay for providing a paper copy? So we all know that patients are allowed to request a copy of their notes once a year, and they shouldn't be charged for that in general. Now many practices have been digital for 20, 25 years, and it's amazing how much paper 20 years of medical notes are, even, where each blood test comes out on a full page of paper just about. And so printing out 20 or 25 years of patient notes is very time consuming, very expensive in paper, not great for the environment, not good for your staff time. There's lots of issues for doing that. And if in general what the Privacy Act is supposed to be doing is about the information, not the physicality of it, is it reasonable for practices to say, look, you've got all that information, it's all on the portal, you can see it all, we're not going to print it out, or we're going to charge you if we do?
Well, yeah, thanks, Lucy. I think this is one of those situations that the Act has the requirements and the code has these requirements, but it can actually be dealt with in quite a pragmatic sort of way. Patients might not know that their information is actually available on that patient portal. You could just have a chat with them in the first instance to say, hey, do you know that is there and you can access it that way? It might also be that they're actually after something quite specific. They've asked for this sort of empty your pockets, give me everything kind of request, but actually they want something, a specific issue that they're looking at. And that's the information that they actually want. So I suppose that talking them through that in the first instance, just the sort of importance of a relationship, is really key there. And that could be a really good opportunity to sort of, you can both be helpful for them because you're giving them what they actually want and allowing them to access it in a way that is easier for them. And it will also minimise the burden on the practice. So maybe it's sort of the first step that's the thing. But the fundamental thing is that access to information is a right. And so if you talk with them and you've explained these things and said, well, you can look at it on the portal things, and they say, no, I want it I want it printed out, I want it in a particular way, then you sort of do have to respect that. Section 56 of the Act allows the individual to request their personal information in a specific way. For some patients, I suppose there is a legitimate reason that they want to access it in that way. So if after you've talked with them about the options, they could access it by the portal, or that you could just give them what they're specifically after, if they still say, yes, I want all of it, and yes, I want it all printed out, then you need to consider that. And then the only reason you can decline that is one of the grounds in 56.2 of the Act applies. And so apart from that, then yeah, you would.
If you think about the hours of labour required by a receptionist to produce this on paper, it is actually very costly for a practice. What would the OPC, the Office of the Privacy Commissioner, the PC, see that it's acceptable to charge the patient?
Yeah, so we've always kind of talked to our members about the fact that if you're providing something on a CD or an X-ray or a particular form of information that's not the notes, that you are allowed to charge for those things. But is there other situations? Is there a situation whereby you can charge for printing out 1,000 pages of patient on patient notes on paper?
I'm looking now at, I guess, clause 6.2 of the code, which is about, if an individual has made that privacy request to a health agency, that is a private sector agency, so primary care kind of stuff, then the agency may, unless prohibited by law other than the Act or this code, make a reasonable charge where on a particular day that agency has made health information available, which is pretty much the same within the last 12 months.
Yeah.
So that's what
you're allowed to charge if
before.
they've had it within the last year.
Yep. So there's also the copy of the X-ray is that other one in there. So if those situations don't apply,
You can't
sorry,
charge.
no dice. Yeah.
Yeah, I think the thing is, when this was written, paper and the notes weren't like they are now. I think that it was in a situation where GPs used to write on little cards and you used to copy them. But actually, the problem is now they're so huge when they come out, and it is such a burden to do it. But as you say, it's pretty clear you can't charge. Unless they've had it within the last year, or it's one of the exceptions like a scan or something like that.
Yeah, and I think this is the one where just maintaining that good relationship with your patient is both really beneficial clinically, but also in situations like this where you can actually be able to have that initial talk with them to actually figure out what it is that they are actually after.
Yeah, unfortunately, often when people are asking for all of their notes, the relationship hasn't gone well, which is the reason why they're asking.
Yeah.
That
is very true.
I appreciate that.
Yeah.
Is it possible in terms of the practice management systems to print to PDF and then ask the question of the requester?
Can I give it to you on a stick?
Would you, I can give this to you as a PDF. Would that be sufficient? Is that ever a step that practices consider?
They definitely do, but patients sometimes say actually want them in paper.
Mm.
And the different PMS systems have different ease of which you can produce them as a single PDF report. There are some where you've got to download the inbox and then download the outbox and then download the recalls and then so
they come separate.
It becomes separately. So it depends on your PMS system as well. But yes, I think a lot of practices now would say, can I put it on a stick? Because actually that, in a lot of situations, is an easier thing for them to do than print it all out.
Yeah, I don't think it's the cost of the ream of paper or the 5 reams of paper that some of these notes take. It's the labour involved. It's the reception time, which is costly. But anyway, that's fine. We can't charge.
We can't charge. And
there it is.
It's a common question we get on our advice line, and doctors can't believe that they can't that they aren't allowed to. It's a shock to many people that they can't charge for doing that. But there you go. That's the answer. Okay, so we're moving on. We're going to talk a little bit about, again, with notes requests, about who is the representative of the patient. And look, the HIPC says that the representative in relation to an individual is, if the individual's dead, it's the patient's personal representative, or if the individual's under 16, and that's the individual's parent or guardian, or if they are unable to consent, a person who appears to be lawfully acting in the individual's behalf and an individual's interests. Now, one of the questions, the reason I'm asking about this is we get a constant stream of issues where insurance companies are wanting the patient's health information in order to make a determination about their cover, or maybe even setting up the insurance in the first place. And the insurance companies do have a route whereby they can get the patient's consent and request that from the doctors. But often they have I suspect it's some insurance agents maybe have worked out that if the patient requests the notes themselves, it's free. Whereas if you ask a doctor for a report, the insurance company has to pay for that. And so rather than making the standard route for a notes request, the insurance company says, well, I'm acting as the patient's representative, therefore you can't charge me and you have to give me all the notes. Is that reasonable? Can the doctor say no?
Yeah, well, good question. We were having a bit of a chat about this one in the office this morning before I came here.
Which is always a good sign. It's always a good sign when everyone's thinking, is it, isn't it? Yeah.
I suppose, the concept of a representative is sort of, they're acting in the patient's best interests and things like that. And I suspect that you might give some advice quite regularly, being like, maybe just have a chat with the patient and just make sure that they understand what that means. The insurance company is acting in the insurance company's best interests at times, and not, which might be different to the patient's interests.
It usually differs from the patient's interests.
So that might be a thing that you could talk to the individual about. But then if you sort of get to the end of that and the patient is insistent that no, the insurance company is my representative and I've signed this this form, which in most cases the insurance company probably has them do, then I mean it's up to you, I suppose, to still assess whether you think that they are truly a representative. But the fact that the patient is pretty insistent that they are is probably a good indicator that maybe you listen to the patient. But yeah.
Yeah, you see, we have exactly that conversation with our members saying, look, a representative is supposed to be acting in a patient's best interest, an insurance company may not be. Also that it may be that the release is going to be much bigger in that situation than it would be if the insurance company made a request direct to the doctors, because very commonly when we get those requests, that the request is limited. Maybe it's 5 years of notes, or notes about specific conditions rather than just everything. Whereas often when we're getting the requests from an agent acting as a representative, they're saying everything. And also the risk to the patient, if we're giving it to the patient, that actually then the patient can actually remove parts or alter it in some way before it's provided to the insurance company, and that may be a risk to the patient themselves if actually the company hasn't got the full situation, and then that makes their insurance invalid. There are all sorts of issues with it.
Yeah, I mean, you also start to think about the withholding grounds when it comes to providing information directly to the person that it's about, as opposed to if it were being shared under Rule 11, whether that would be a different sort of kind of information that might be disclosed in that way.
It's hard because, and it's not common, but every now and then we get a whole flurry of calls about it. And I think that having had that conversation with the patients, often we get to the point where we're saying, look, the patient's making the request, release it to the patient, or if they insist that we're releasing to the representative, make sure that you've documented the risks of the risks of that to the patient, and that we have concerns about the approach that these people are taking, and if that's the approach they're taking in this situation, does that extrapolate into the relationship in the whole, and is this person truly your representative? It seems rather unprofessional to me for an insurance company to take that approach.
I guess, though, there has to be a line where it's not the doctor's issue in terms of giving their patient commercial advice or just life wisdom. If you've been really clear about the privacy issues and to say you've signed this piece of paper that says, Mr. Smith from the insurance company is your representative. Mr. Smith has asked for all of your notes. I just want to double check that you understand what that means and you're okay with that. And the patient says, yes, that's what I want. I would write it clearly in the notes that that conversation has taken place and do it. If and this is not so much a privacy issue, but when can GPs charge for things?
Well,
Discussion
that's exactly what it comes down to, because the insurance company is generally their requests. You'll write a report and you charge for your time to do that.
Well, I guess that's what I was coming to. Is there's a distinction, I think, between satisfying a Privacy Act, IPv6, Health Information Privacy Code access request, for which there are rules about when you can charge, and just assume for the moment in most cases you can't charge to just push print on those notes, no matter how burdensome it is for the person managing the printer. But if they want a distillation or an analysis of that information, or a report or an opinion or anything like that, charge for your time.
Yeah. So if they're saying, I want my notes but only in relation to this issue, then as soon as it becomes that, you can charge, because you actually, it takes a lot of time going through picking out issues.
But if they're asking for, say, the medical professional's opinion on a particular thing, or a distillation, like you say, maybe a summary of recent issues, IPP6 does not give the patient the right to demand that the doctor makes new notes. Rule 6 is about accessing the information that is already held about the individual. So if actually what the insurance company is after is a description of a certain thing in a way that isn't already there in the notes.
But one of the issues, and this is a common ACC issue, in fact, is where ACC say we only want information about this particular diagnosis or this particular concern. And if an insurance company says, look, I'm acting as the patient's representative, I want their notes, but I only want their notes about their blood pressure. So that means, or I only want their notes about, their gallbladder problem. Then not only do you have to hit print, you've actually then got to go through everything and pick out all the bits about their gallbladder and their blood pressure. That is such a lot of clinician time. So can you charge for that? Because it's not a complete print of their notes, but it's their notes with respect to specific diagnoses that a clinician is going to have to spend time collecting separately.
Well, I still don't think you can charge that if it is being done as a representative, a IPP6/Rule 6 request for information that is already there. I can make an IPP6 request from an agency and say, just give me the information about those kind of things. And actually, in a lot of situations, that's easier for the agency than actually printing out everything that there is about me, which is what we were just talking about before. But do you see a distinction between I just want these 4 things and I want everything?
What happens, though, for GPs in particular, is that in one consultation, we don't just deal with their blood pressure, we deal with a whole lot of stuff. So it does require going through each consultation and just picking out the bits of each consultation that relate to. So you are talking about a lot of clinician time in it, and it does need to be the clinician concerned. You can't give that to a receptionist to do.
Yeah, I appreciate that. But also because they are using this Rule 6 mechanism, when you're giving it to a representative, it's sort of like you're giving it to the individual themselves. So do you need to fully redact all of those kind of things? And those are the kind of things that you probably need to let the patient know about as well, is that, like you were saying before, if you're doing through that sort of traditional method of where you're getting the information between the insurer and the GP, the purpose is sort of nailed down in that you say, I want this information for these reasons. But when you're starting to use this IPP6 route, it's not that all bets are off, but it's sort of that all bets are off, if you see what I mean, that you aren't, you are essentially being that patient when you're asking for the information. The insurance company is in that situation.
I think it's a unsatisfactory situation, I have to say.
I still think they should be using the other.
I think, and it would be very helpful if somebody would change it one day. But I also think that the advice we often give in those situations is release the whole thing. Because actually, okay, so it's going to take an hour of reception time to print the notes, but it's going to take 3 hours of doctor time to take out all those bits of health information. And actually, you're not going to breach, if you're giving it to the patient, you can't breach their privacy by giving them their own information.
Exactly.
So we can just give them the whole lot and say, here, you sort it out. You find your blood pressure and your gallbladder bits. And say, because you've made a health request this way, we're not going to accept your request to just give you these bits, because that is an unworkable thing within our current health environment. And therefore, I'm giving you the whole lot. And they can't complain about that, can they? If I'm giving them their whole notes when they've actually asked for bits of it.
I mean, I've never been part of a complaint for a situation like that, so I've never had to think it through and see how the Privacy Commissioner's Office might respond to it. But I think transparency about and communicating what's happening will be a good insulation against risk. So generally speaking, the starting point is that me as a patient, I should be able to, in principle, go to my doctor and say, look, I just want information about my heart condition. That's a starting point, but because if you're giving me information directly to me, there's nothing in there that I'm not entitled to. I think it would be acceptable for a doctor in that situation to say, well, I'm not going to do an exercise of redacting. There's some obvious things I won't bother giving you because they're clearly not about your heart, but everything you want to know about your heart will be contained within the remainder. And if you want to have a consult with me to then discuss if there's anything in here you don't understand, book a consult. If it's the situation with an insurance company and we are talking about 3 hours, and I could easily see how it would take 3 or more hours.
I've spent 5 hours doing one once.
It would be an incredibly tricky thing to do, to just pull out some specific information from decades of notes. I'd be inclined to be really clear go back to the patient and say, look, this has happened. It's impossible for us to pull that out with any confidence. This is your health information. We are giving it all to you. And you resolve this issue with your insurance company, but we can't spend that time. If you want to make a complaint about us, we'll get the lawyers involved and work through it. But ideally, dear patient, what you'll do is get the insurance company to go a different route so that we can actually charge for our time, which is valuable. And doctors are they're running businesses themselves. They simply don't have the time to do this for free.
I think the other issue where that comes up is with ACC when they're requesting reports from doctors, and this is not to do with charging, actually. It's where they say a patient has made a claim for a mental injury, and because of that they are actually allowed to request notes prior to the date of the injury to see if that is relevant to the injury. And so you'll get a request saying, please can we have 34 years of this patient's mental health notes. And that is, it makes your heart sink when you see that in your inbox, because you think, how many hours of my weekend are going to be spent doing this? And some doctors, literally cry when they get one of those requests, because it's so just, it's really hard, because often the patients that are involved, they have got very complex histories and it is very difficult to actually tease out that from decades of notes. And so sometimes, again, in those situations, and I'm not sure whether this is something that the Privacy Commission would accept, is that you can say, look, the patient can consent to a larger release if they wish to. And then the doctor can say, I'm not going to promise to get every bit of consult out of here. Are you, and ask the patient's consent to be more general in the information they release for the purpose of practicality. Is that reasonable?
I don't know what the actual basis for that initial sharing is, so it'll often come down to actually what that authority is there, about whether that is already sort of tied down in that way. But you could, talk to the patient. It's the patient's information. And if they're comfortable with something being done in a certain way, then often that will, and then that you document that conversation.
Yeah.
That will often get you a long way.
Yeah, my understanding of how that works is that when patients are making an ACC claim, then part of that is that they have to give consent to ACC having access to certain of their health information in order to determine the claim. And ACC will then come directly back to the doctor. But, and this is a good thing, that ACC, I think, is quite mindful of only wanting what's going to be relevant to their decision. And so they will say, here is the piece of paper that says I've got authority to ask for this, but I only want from the last 3 decades information about any presenting complaints in relation to mental health. And that's really hard. And I think it can't possibly be wrong to at least explore with the patient whether they hold, because ACC will always say we only want this because they've been burned before. I've seen the cases. But you can explore with the patient, I think, whether they actually mind. They might.
I think that's the key.
Yeah.
The key is that you speak to the patient, because you're right. There have been plenty of patient complaints about excessive amounts of information released intentionally or unintentionally to ACC. Yeah. So I think so long as we involve the patients, ensure that we've got explicit consent, then you can't go too far wrong.
So the other question we often get around representatives is after a person has died intestate, and it's often a young adult, and at times they have completed suicide, and their notes contain extensive sensitive mental health information. We know that normally the representative of a patient after death is the executor of their will or the administrator who's been appointed by the court. But often in these cases, the estate may not be of a size which requires an administrator to be appointed, and there may be no executor if there's no will. When a family member approaches the doctor asking for a copy of the notes, what factors should they be taking into account when deciding if that family member is acting as the deceased patient's representative? Stephanie, can you give us some thoughts about how we decide who the personal representative is?
Yeah. So if there is an executor or an administrator, then that is quite a bit more straightforward, because Rule 11.5 gives that representative, so their executor or administrator, the right to make an access request. But if they don't have an executor or administrator, it can be quite hard. And I think something where people sometimes get a bit mixed up is if it was about someone who there was an enduring power of attorney before they died. Sometimes people just assume, then that will also be the executor or the administrator. But that's not always the case. So I think that's just sort of something to bear in mind. Just if there was an EPA in respect of that person, that doesn't necessarily mean that person suddenly gets all of the rights once the person has died. So if someone makes a request who is not the legal representative in that way, then an agency can choose whether to disclose the information if it reasonably believes that one of the other exceptions that sit there in Rule 11 applies. So the key thing with Rule 11 is that this is a discretion about whether an agency shares the information or doesn't, whether it wishes to disclose that, and you can't be forced to exercise that discretion, I think, is the key thing there. But there are a few subsections that sit under Rule 11 that might be relevant in situations like that. There's one, so I think it's 11.2b, which allows a health agency to disclose information to a near relative of the deceased person in accordance with recognised professional practice. So the first thing that an agency has to do in this 11.2 sort of space is consider whether the disclosure is contrary to the patient's or their representative's wishes. If the patient hasn't said either way, then that might be an option. So then that's up to the agency who holds the information about whether they can share that under that.
Thanks for that. I'm actually thinking of a call I had today, in fact, about trying to choose the representative of a patient. So this was a scenario where a patient had died intestate, so no will, no executor, and the sister of the patient was requesting the notes, and the doctor was ringing up saying, how do I decide whether that person is the representative rather than another family member? And often in these situations there can be conflict between family members about who considers themselves to be the representative of the patient. And so I'm just thinking if you've got any advice about how you come to that decision about who's the representative?
Yeah, it's not an easy decision to come to, for sure. It's up to it's the doctor's discretion about who that might be, and they can sort of think back to the relationship that they know they had with the patient and actually what they know about that patient's family. That might be a good indicator of actually who the appropriate person to be the representative is. It won't always, and it will sometimes be fraught, and it is often really tricky, and I don't actually have a better answer than that. It's really hard. Take each one as it comes.
But if you make your best guess, and so if the doctor says, these are the reasons why I think this person is the representative, this is who used to bring this patient in, this is someone who they've named as their next of kin on the enrolment form, these are the reasons I think it's the representative, the GP then does have the discretion to release information to that person.
Yeah, in accordance with Rule 11. And the key thing will always be to document the reasons why you think it is like it is.
Okay, so you have to write in the notes somewhere, I'm thinking that Mrs. X is the representative of this deceased patient because of these factors, and therefore that's why I'm releasing to her.
Yeah.
So just to be clear, Rule 11 of the Health Information Privacy Code is really about the gives you lawful reasons why you can release without consent of the patient.
Yeah, well, consent can come into Rule 11, but obviously if the patient is
right.
dead, you can take into account what you know that their wishes may have been before they died. That can be relevant. But obviously a dead patient cannot consent.
Yeah.
No.
No, I'm just thinking for our listeners, when we talk about Rule 11, they probably think, what is Rule 11?
Yeah, Rule 11 is the disclosure principle in the HIPC, and it sets out a number of reasons why you can share information in certain situations.
That's great. Thank you.
Yeah, along the same lines, ACC often send a form to doctors after a patient's death called an ACC 21, which allows the family to access a claim if the death was related to something that ACC would have covered. And again, in these cases, very frequently there's no will, and ACC will send a consent form with a family member's signature on it. So would that be the same kind of thing about where the doctor's considering whether that family member's consent to ACC will allow you to release to ACC?
Does ACC also have a think about whether that person is truly the representative at the point where they've received that form? I'm not really sure how that would work.
Well, I think the problem is that the doctors don't know that either. You know, that actually you get this request form with a relative having signed it. And often the doctors don't necessarily know who the person who signed it is. So in that case, would the doctor be expected to take more care to go and find out if they are the representative, or
is it that we accept that ACC have determined who the representative is for the patient? Would that be reasonable?
I mean, I can't just give a green light to particular activities,
yeah,
obviously,
fair enough.
But yeah, it's something that ACC should have done and may have done, and if there's a way you can maybe satisfy yourself that has happened. I don't know if they make their process for these things public. I know that a lot of their processes and protocols are published on their website. That might be relevant. But again, if it's a disclosure under 11, it is always a discretion, and if you have a reason to believe that it's not the case, then yes, you absolutely are entitled to ask more questions just to satisfy yourself that you're making the right call by sharing this information.
It's very complicated sometimes.
It's so complicated. It's really hard.
Yeah, it's interesting to get a sense, Lucy, of just how often this comes up. It sounds like it could be frequent. What I would say, but it might be not very helpful advice if it's a very frequent issue, is that where you're being asked to exercise a discretion under the Health Information Privacy Code and you are concerned about getting it wrong, so if you're aware, for example, there are two camps in the family who are not getting on, then that is the sort of case where it might be quite helpful to call NPS, and documenting your reasons is always going to be helpful, but sharing the problem and getting another perspective is going to be helpful as well. So there are some things we can be confident about and the answer is black and white, and other things where if you're weighing competing issues, then take the time to get advice if you can.
Absolutely. Yeah, I totally agree.
And I think the ACC issue, actually, we have been trying to find out what the ACC processes are and get some reassurance from ACC as to how they determine that. I don't think we've heard back from them yet, but I think that is something that we have tried to do. So that's been very interesting, and I've learnt a lot. So hopefully our listeners will have learnt a lot too. We have got lots more to talk about with Stephanie, so we are going to come back for our next podcast and we'll have Stephanie here again. Thank you to our listeners for listening to the podcast. I hope it's been helpful. Our next podcast will be covering some further privacy issues, so we hope you'll tune in for that. As we have just said, our discussion today is about principles, and often there are specific issues in each case. And if you have a specific privacy question, and members of MPS, please call us on our advice line, which is 0800 2255 677. And if you like medical protection podcasts, please subscribe and leave a review. If you'd like a podcast on a specific topic, you can email us on nzpodcasts@medicalprotection.org. So thank you everyone for that very interesting discussion.
Thanks,
Excellent.
Stephanie.